topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon. Welcome to another Ask the Experts, where we bring you the top experts in the field of legal, health, financial, and home improvement. We have got an incredible show for you today. Everybody loves the Kay Rimbaum shows. There's so many people nowadays who live in a community association, and they have so many questions. They don't have access always to an attorney. And what we do here is we bring on one of the top law firms in the state of Florida, Kay Bender Rimbaum. And for the next 50 minutes, they are here with us to answer your questions. We also are going to be talking about seminars they have coming up. What's so great about Kay Bender Rimbaum is they love when it comes to educating the public, and they do so many different seminars and classes that are all free that they give their time for. They have been with us for about 10 years now. Let me welcome to our good guy attorney Alan Swartseed. Hey, Alan, good afternoon.
Afternoon, Steve. Thanks for having me. And before my partner cuts my head off, Kay Bender Rimbaum, because if you leave Mike Bender out, I might not be here next week. So just a heads up.
Oh my gosh.
Just had to clarify that one.
I am so glad you did that. I've only been doing this for 10 years. It rolls off the lips really easily. I hope I'm not putting you on the spot, but I heard yesterday that the governor signed off on something for HOAs.
So
did I hear that wrong?
No, you heard right. We've got a bunch of bills that have been put finally on the governor's desk. The one that passed, we talked about last month. That was the one regarding condos, specifically hurricane protection for condos. DBPR hasn't really done what they need to do for that to really go into effect, but we did the math within the firm, and it really seems like there's less than 200 condos in the entire state that are going to get that funding this year. So we really want to advocate for people to use that money for hurricane protection, or at least ask for it, because the bottom line is you're protecting your building, you're protecting your residents. And if that money's not used up this year, I promise you it won't be available for the next 200 or so when next year rolls around. The one that was recently passed was pertaining to, I think it was HOA hurricane protection, like you mentioned, Steve. And it's specifically that all homeowners associations are going to actually have to put in place specifications. So you get your architectural review process. There's got to be specifications regardless of what else you have under this new law, which did go into effect the day it was signed, which was a couple days ago. I apologize. I was on vacation, so I'm not fully up to speed because I literally just got back specifically in time to be on this call with you, Steve. But I do know from reading emails while I was away, it's basically the HOA has to put in place specifications as to what type of hurricane shutters, hurricane protection, hurricane-proof glass, etc. All of that type of stuff is going to be allowed in the community. The association can't say you can't have that type of hurricane protection, but they can specify what type what it's going to look like, what materials can be used, etc. So thanks a lot for putting me on the spot right when I was coming back from vacation, Steve. But I hope I handled that okay.
That was, I just didn't hear the whole thing. And I said, wow, the governor finally signed something that has to do with HOA or condo, but I didn't get to hear what it was because there's a lot of things that we're waiting on.
That's what I was about to say, Steve. We've been waiting. We've been saying during this show for 2 months now, I can't wait to talk about the stuff that's actually on the governor's desk, being signed, etc. My understanding is the governor has, I think it's 2 weeks, 15 days, something like that, to actually sign off or veto each one of those bills. If the governor does not do so, they pass. So there was a batch of 4 or 5 of the major ones that are up right now for the governor to review. If he ignores those, my understanding is they'll pass within another week or two. So next month, we should have everything to discuss that needs to be discussed. We've actually got a webinar already scheduled for whatever it is that ends up passing. I think Mike Bender is going to be teaching that. We'll talk about that a little later, but that is something that, like you said, we do find education extremely important at the firm. And one of the things that we think is important also is just staying up to date on what's going to happen in the law. We don't know right now because there's so much that's still on the governor's desk and a few that haven't even reached his desk yet. But hopefully we'll know again. I'm sorry that this is the 3rd month in a row that I'm saying this. Hopefully by this time next month, we'll know what's passed and what hasn't, and we'll have the ability to sit down and discuss it. But those 2 bills have passed and have now become law. Now, for the first one that was passed when we spoke last month, DBPR still has a bunch of stuff they have to do. The most important one being they have to actually create the form and the way that these requests are supposed to be submitted. Until then, there's really no way to apply for those funds. But the goal is that, there be 500 to 1,000 condos that actually ask for the money, so that next year there's still money available for those that haven't already taken advantage of it. If the government's going to tell us we got to do all these 8 million things and reserve for all these new mandatory reserves and do a bunch of studies that were never required before, it's good, in my opinion, that the government is also funding some of the hurricane protection that I think every community association in Florida needs, especially condos.
Well, I want people to, I'm glad you said that. And I know there's a lot of things that have not been signed, which I am not getting into. And hopefully some of them will be signed by next month and we can get into them. We do this every time you come on. We talk about Kay Bender Rimbaum and what you do, but it just seems like we get so many new listeners every month that people are finding the show, love the show. If you don't mind, tell people what all Kay Bender Rimbaum does.
Sure. So, Steve, we're a law firm that's existed since the 90s. All we do really is represent condos and HOAs and a couple co-ops here and there. They're a little bit rare in Florida. But we've got 20 attorneys, 7 of whom are board certified in this area of law. One of who you're speaking with right now, will be board certified as of this Saturday. It doesn't kick in until this weekend, June 1st. But I'm proud to announce that I did pass the exam, got my results just this week while I was on vacation. So that was a great way to spend the week. But another one that's board certified in construction law, representing community associations is pretty much all we do. But we do find the education piece and the communication piece of our practice to be some of the most important. When I say communication, I know that there are a lot of law firms out there that are taking 3 to 4 weeks to acknowledge that a question was asked. If I take 3 to 4 days, you need to reach back out to me because I didn't get your email. Usually it's 1 to 2 business days at most before you're going to hear back from me. And just for those who don't know the firm at all, we do have 4 offices. Pompano's our main office. Palm Beach Gardens is another. Tampa's another. And I manage the Orlando office of the firm. So, that's hopefully that's enough information for those of you that are on here. If you want to reach out to me, feel welcome to do so. If you're not represented by counsel, you're not happy with your counsel. But we're just here for some questions to be answered today. So I appreciate the opportunity to talk about the firm a bit, but let's go ahead and get to it.
Absolutely. And before we start, Alan, I have to make an announcement. Um, I am. We have a production person, Juan. I'm going to ask Juan, if you will put my email address up on the scroll. It is really difficult for me to do the show live and do the chat line and do the phone. And we're not going to be doing the chat line anymore. So we're going to ask you to send your emails in. I won't be able to answer them that week, but we'll keep them for the following week, following month. So if you have a question, I apologize. It's just too hard for me to do all the things I have to do because I have to go to a whole nother window at the chat line. So we're going to put up my email address, and please continue writing. And this way we'll be able to get those questions on. Okay, maybe that way it'll work. So I just have it's very difficult for me to get to the chat line. We're going to go start with questions. And boy, you've got a busy month, don't you?
We do. We've got a lot going on in June. It's been a busy May, and it's not going to get any easier this coming month. So we've got June 4th. We've already got our first class next Tuesday for the month. We've got updating your governing documents with Kirsten Hens. That'll be a Zoom. June 5th, just the next day, we've got a legislative update in person in Weston. June 10th, we've got the CAI update on all of the changes that hopefully by then will have been finalized. I think that's the date that most of the bills that are on the governor's desk will either have been vetoed, signed, or will be automatically approved by the governor. We've got June 12th at noon, that legislative update session. We've got association leadership with hurricane prep via Zoom on the 12th, via Zoom. Another couple governing documents classes. I know I've got a condo board certification class coming up at the end of the month. We just, again, you're absolutely right, Steve. It's extremely busy. The easiest way to know what's going on, one, sign up to get notified when we have these classes. But two, if you don't want to do that, you can go to our event calendar at kbrlegal.com. If you click on the top that says KBR calendar, you can sign up for all of our classes that are going to be held throughout every month. They usually get put up about a month in advance, and feel free to register there. If you'd rather contact me directly, feel free. It's as@kbrlegal.com, but our website is a great resource, including, Jeff Rembaum's articles, Robert Kay's articles. I mean, again, that education piece is extremely important to the firm.
Okay, let's go to, these are all the letters that we've gotten in over the past 4 weeks. We're going to start with Harry in Orlando. He wants to know, how do I find out the association records so I can look over them?
You send a request to inspect them in writing, and that's easy. That's the easiest way to do it. I mean, the association has a legal obligation to produce those records for inspection. They need to produce them for copying as well. If you want to take your mini scanner or your phone or your tablet and take pictures, you're allowed to do that. If you want them to copy it, then once you exceed 25 pages, you'll have to pay for those copies. If there's no copier in there, you'll have to pay for Kinko's or someone else to do it for them. But that's the easiest way. Send a written request to review the records, and they have 10 business days from the date they receive that request to actually provide the records, or there are some penalties associated with intentionally failing to produce them. So the short answer is ask for them.
And you will get them.
Let's
go to
so.
Manny in Orlando. Yes. Manny in Orlando wants to know, regarding mandatory reserves, please explain single-story condo reserves. I didn't know there was a single-story one. Should we still fund the reserves?
So those single-story condos are not going to have the mandatory reserves that you're thinking of, which are the structural integrity reserves that everyone's been talking about the last few years since that building collapsed in Surfside a few years ago. The ones that you'll need to have are the ones that have always been in place, at least since I started practicing for the last almost 15 years practicing in this particular area of law. Those are going to be your roads, your roofs, certain things like that. But it will not include, for a one-story building, the actual mandatory reserves that are now statutory. It'll include the old statutory reserves. And you'll probably still have the ability to waive, underfund, et cetera, with a member vote on those particular reserves. So I guess good news for a one-story condo. The shorter answer is I do still think it's a good idea to put those reserves in place to protect your buildings. But, if a one-story structure falls down, hopefully you have time to just run out the door. It's not like an 18, 20, 30-story building where, you're going to have a tougher time getting out if there's a problem with the structure of the building.
I had a phone call the other day that I wanted to bring up. It was a board member who listens to the show, loves the show, and he said, "What do I tell these people that I'm looking in the eye to that live on a budget with all these rates going up?" And I thought about it. Hasn't, and maybe this is not the way to describe it, but hasn't for the last 20 or 30 years, things have been kicked down the road. So they haven't had to have those expenses, but it's kind of all catching up now.
Well, that's part of it. I mean, some of it is that your building wasn't old enough to need this stuff yet. A lot of these studies are being done for 30, 40, 50-year-old buildings. Unless you're having these structural integrity studies done every 10 years from the time that your building is created, there's no real reason you would have done some of this maintenance before. So it's not necessarily that it's even on the previous boards for not doing it. It might not have been necessary. It wasn't statutorily necessary until 3 years ago. So, what do you tell them? You tell them it's not my fault. You need to talk to your legislators and reduce the amount of things that we need to reserve for, or give us some relief and, let the association do what it needs to do to properly fund these things. The bottom line is, if associations were doing the maintenance that was required, then the reserves wouldn't be necessary. I agree, with that part. Because all an association should need to do is be able to increase the amounts that you're spending every year for non-recurring expenses. And if someone can't afford that, I hate to be blunt, but that's kind of their problem. The reality is, you can tell these people, it's not up to me. I don't have a choice. It's my legal obligation as a director to include these things in the budget and tell you need to pay them. Because if I don't do it, then not only can almost all of the members come after me for breach of fiduciary duty as of 2027, I think is the year that pre-suit mediation for that type of situation kicks in. But there are also administrative agencies that'll come after the association, charge you more, and make you do it anyway, and possibly come after me. So the answer to those people is, I don't have a choice. I wish I didn't have to do this. We're looking at alternative funding methods that won't cost you so much up front, but you really need to be talking to your legislators and not me. I'm not the one that made the decision other than to comply with my legal obligations.
Alan, does that help people contacting their legislator?
It depends which legislator. Some of them really do care. And some of them really do listen and try to understand how these things are impacting people. I'll be blunt, some of them really seem to only care about votes and don't even ask the attorneys that practice in this area whether what they're doing makes any sense, whether it's feasible, or whether it's just creating more issues. I mean, this entire area of law, this SIRS and milestone inspection reports issue, came about because before the information was available, everyone in the legislature, or at least a lot of legislators, decided that this problem was the result of failing to maintain certain things. We now know for almost a certainty that the real cause of that building collapse in Surfside a couple of years ago was a construction defect, that these studies might not have even caught if they were done properly. So, for me, that's
I wondered about that.
right. I mean, to me, that's like, oh, okay, maybe we repeal this altogether. But because so many people attach their names to it, that's no longer an option for a lot of legislators who would like to get reelected in the future, and who caused a lot of problems for a lot of Florida communities. So, I hate to ever speak ill of any legislator. They're doing a tough job. They're working a lot harder than people recognize or understand. I just wish that they listened to more of the people that are part of the Condo committee of the Florida Bar that met today and actually tried to understand how these things would impact the people that they're allegedly trying to protect. And the question that you asked me before this one is exactly the impact that we're having. We're seeing where people won't be able to continue living in condos because they can't afford it. They're on fixed incomes, all of these other things. You're going to go from a multi-million-dollar condo, and nothing wrong with living in a trailer, but that's where a lot of these people have to go because they're on a fixed income and they can't afford to go out and try and pay to maintain a set standalone residence. It's just not feasible.
Let me go to Richard in Kissimmee. He said, I'd like to know how to handle board members that don't answer questions. And I got to tell you, Alan, we get a lot of email about people wanting to get questions that they don't feel like they're getting answers from the board.
Well, I mean, if the board's refusing to address an issue altogether, there's legislation that's pending right now. If it's adopted, the board would have to have a certain amount of essentially Q&A sessions. I think this is HOA only. But I think it's, you'd have to do that a certain amount of times throughout the year or something of that nature. But the reality is, in a condo or an HOA, you've got the ability, if you want questions asked or you want an issue put on the agenda and addressed, to gather enough votes in a petition to ask the board for a special meeting and to put that specific issue on the agenda if they're refusing to answer questions. The other thing you can do, if it's a question that might be answered by inspecting association records, we discussed that option earlier. You send a records inspection request, and you can, but you don't need to specify, I want to view these particular records pertaining to this issue. If you're trying to find out what a contract requires of the association, ask for a copy of the contract. If they're refusing to answer questions about the contract, inspect the records, which should include a copy, and take a look at it yourself or make a copy and send it over to an attorney who's qualified to, investigate what it says and what it requires. Those are the two main avenues as of right now that you would take if the board is ignoring your questions. And it would be the records inspection or the special meeting that must be set once you get the right number of petitions, or get a petition signed by the right number of members of the community.
We're going to go to our first break. Alan, you have a main number that's good for all the different, for Orlando, Tampa, Palm Beach, and Pompano. Let's give out that phone number and your website again.
Sure. It's 954-928-0680. And that's going to reach, like you said, Steve, all of our offices, including mine in Orlando. And the website is www.kbrlegal.com. My email, which is the easiest way to reach me, as@kbrlegal.com. That's Alan Schwartzide, AS.
Beautiful. We're going to go to break, and we come back. We've got more with Ask the Experts. K. Bender Rimbaum. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we're back here. This is the last Thursday of the month, which means K. Bender Rembaum. They're our community association law firm. We're here with attorney and soon to be board certified Alan Swartzseed. Hey, congratulations on that.
Thank you. Appreciate it. It was one of those really harrowing experiences where you're waiting for 2 months to find out what happened. You always think you passed if you actually know what you're talking about, but you never know. So I appreciate it. It's a nice honor after putting this much time and effort into a specific field of practice for the Florida bar to recognize it.
Yeah, because it's very limited to how many attorneys are board certified. It's an incredible honor, and I'm glad you're part of the show. We're going to go to Max in Orlando. Developers are turning the board over. I guess when you have a new community, the developers are actually the board members. Is that right?
So yes, when it first starts out for the first couple months to years, usually the developer actually assigns who is going to be on the board. Now, gradually, as they sell more and more lots or condo units within the community, the board starts to be comprised of the members. And once they hit certain thresholds, milestones, whatever you want to call them, eventually this turnover happens, which is when the entire board is comprised of the members rather than the developer getting to appoint anyone.
Well, he said we are having new elections next month. Can new board members go directly into a organizational meeting? They're doing this for their election officers. This is the first I've heard of an organizational meeting, so you might want to describe that also, Alan.
Sure. So, you have your election meeting. The members get to decide among the other members who is going to be on the board. Those are your directors, the people that make, I'd say, 75% or more of the decisions for your community. So the things that the board gets to vote on are the things that these individuals will decide. Then you've got your officers. Those are the people that actually have specific roles within the community. So, for example, your president is the one that's usually going to sign contracts, speak for the association, preside over the meetings and things of that nature. You've got your vice president who doesn't really have to do much unless the president is unavailable. Your secretary, the person that actually keeps notes and keeps the records, et cetera, unless you've got a manager who does that. And then the treasurer who does the same thing with the money and the accounting and all of that. So the organizational meeting is when you decide among the directors, usually, who are the officers going to be. So that organizational meeting is actually a board meeting comprised of the new directors to decide who is going to be the president, who's going to be vice president, who's going to be secretary, who's going to be treasurer. And you may have other random positions, but usually it's those four. So the short answer to the question is yes, absolutely. That's actually common to have the organizational meeting immediately following the election meeting, the turnover election. And then once you have those people in place, then usually they'll decide, okay, when's the first official board meeting going to be that they'll start conducting business beyond just deciding who's going to be the officers among those directors. Now, I say among the directors, that's not necessary. It just depends what your bylaws say. But so again, the short answer is there's absolutely nothing wrong. And actually, it's common to have your organizational meeting to decide who those officers will be, which again, the members don't get to vote on. This is a board meeting immediately following your election meeting, whether it's an annual or turnover meeting, by the way.
We also get a lot of letters about conversions of tennis courts to pickleball. This is from Jack in Orlando, talking about replacement reserves on a 40-line item. Can the board repurpose the money for the pickleball court from the conversion of tennis courts?
So you called it a reserve. The question that your lawyer should be really asking is it really a reserve? Because in a condo, the reserves are established usually by statute for the most part. In an HOA or in a condo, if they're not statutory, which HOAs have no statutory reserves, they need to actually be something that's been established. A lot of people have unofficial reserves, which is just a line item on the budget, but it's never been established by a member vote, by being described in the declaration or other governing documents, or being created by the developer. It's just, well, we put money aside for the tennis courts. If it's an unofficial reserve, you can use it for whatever purpose you want. I don't care if you use it for, you talk about pickleball courts. I don't care if you use it for pickling tomatoes. It doesn't matter. It's not a reserve. You can use those my mind went blank. It's a word that starts with O. But those operating funds for whatever you want. Thank you. Sorry about that, everyone. If it's a true reserve, then the members get to vote to use it for a different purpose. The question is whether using it for pickleball courts instead of tennis courts is a different purpose. The answer, in my opinion, depends whether there's a different type of maintenance for pickleball versus tennis. If it's just in its practical use, to me, that shouldn't make a difference. But if you're changing the net, changing the court to be a different size, because I haven't actually played pickleball. I think the court is smaller. If you're making those kind of changes, painting different lines that, interfere with tennis, that's when I would say you probably want to get an opinion from council as to whether that's a material alteration of the common areas, meaning it's visibly changing the aspects of those common areas, which may or may not matter depending whether you're an HOA or a condo and what's in your declaration. But when it comes to the specific question, whether it's something that requires a member vote is really just going to depend whether it's a real reserve or just money that you are holding in operating funds for the purpose of the pickleball court, in which case you can use it for whatever you want. The fact that people say it's a reserve doesn't make it one.
Okay. Alan, would you mind going over your schedule again? We've got 4 people who missed it, so if you don't mind going over it again.
Sure. We've got June 4th at noon, updating your governing documents. That'll be on Zoom with Kirsten Henza. June 5th, 6:30 p.m., legislative update in person in Weston. June 10th, 11:30 a.m. This is Zoom. CAI FLA, which is the Florida legislative branch of CAI, which is one of the largest community association groups in the nation. That's going to be a session update via Zoom. We're going to have Lisa McGill, one of our attorneys, who's specifically going to be speaking to the changes that were made in the legislature. So that's not one of ours, but we've got one of our folks that is going to probably give some really important and valuable information there. And then June 12th at noon, we've got association leadership for hurricane prep. I think, again, that's Mike Bender. And I know I have a condo board certification class at the end of the month. My guess is we'll have more that gets added in as the month goes on and we see what actually gets adopted, because there are certain things that might become more important and worth doing a seminar that we didn't plan to do based on what passes and what doesn't once we find out what's past the governor's desk, so to speak.
Okay, let's go to Melissa in Orlando. She has a condo. If your docs are changed and you never voted to change for the new rules, what can I do?
You can follow them, and that's about it. If no one voted, that's a problem. But if you're saying that you individually either chose not to vote, didn't get notice, in which case you might challenge the amendment on that basis, or just didn't show up at the meeting and found out afterwards what happened, you basically have to comply. There are some exceptions. Most of them pertain to new leasing regulations, where depending on what goes into this, it might be that only the people that actually voted in favor of the change or bought in after the amendment was actually recorded will be subject to the amendment. But pretty much anything else, once an amendment goes into place, unless you've got a basis to challenge the procedure or the fact that, for example, you can't say no Jews can live in this complex. There are certain things that are just not legally binding because they're considered invalid. But if it's in the declaration, almost anything that's in there is going to be probably binding on everyone in your community, unless you can find a procedural way to knock it out and go through an actual lawsuit for a judge to say it's not a valid amendment. So chances are the short answer is going to be, what do? You follow the governing documents as amended.
Okay, Stephen in Orlando, with all the new rules and regulations for condos, is it going to be harder being a board member?
Oh, 100%. There's no question about that. It's already harder being a board member. There's a lot more that you're obligated to do. Some of the things that are going into place or potentially going into place are additional educational requirements. Hopefully, those will actually help more than they hurt, because you'll be going to a firm like ours that specializes in this area of law to get your education, so that you're actually learning what it means to be a good board member, and some of the things that might be more complicated and difficult that are making it more difficult to be a board member, you learn to do them the right way. But the bottom line is, yes, absolutely, it's getting more difficult. And frankly, that's partially intentional from what I can see on the part of our Florida legislature. They're adopting things that, frankly, I would not want to serve on a board if I was subject to some of the stuff that directors need to do. I know that can hurt some of my clients by saying that, but you do have protection. You're also judged by what I call the dumbest person in the room standard, because the Florida legislature and Florida case law basically say you have the highest duty imposed by law to make sure you do what you reasonably believe to be in the best interest of this association and not in your own best interest. But if there was a reasonable basis for you to believe that what you were doing was the right thing for your community, then you shouldn't be in trouble on a personal level. The association can still get in trouble for it, but not you personally. The other things that I recommend, if you're concerned about this stuff and you don't know whether it's going to be more difficult to serve on your board, make sure you've got directors and officers liability insurance for your association. That's going to protect the association, and make sure also that you've got an indemnity provision that says the association is going to pay any damages that are awarded to someone that sues the individual, because then at least you're somewhat protected, unless you really went above and beyond and used your position to basically attack someone or make more money.
Jared in Altamonte Springs, what types of claims are typically covered by HOA insurance?
Well, that depends what kind of insurance you're talking about. I just mentioned directors and officers liability insurance. That's usually going to cover claims only against the directors and officers of the association. I have occasionally seen those policies cover the entire claim, even though the association was also named as a party. So that might cover damage claims. You've got your umbrella insurance, whatever you want to call it, your liability policy, that's generally going to cover people that sue the association because they allege they were injured in some way. What's really not going to be covered for the most part is where someone tries to say an amendment is invalid or something of that nature, unless there could be actual damage to the association as a result. And keep in mind, this is what these policies are supposed to cover. These insurance companies are trying to find every possible way out of presenting coverage. So, for example, I've come across a couple situations where the actual situation was 100% clearly covered under the policy, but because it was only an offer for pre-suit mediation and not an actual lawsuit, sorry, it's not covered yet. So the association had to go out and spend $2,000 to defend this lawsuit, didn't settle at mediation, and then the insurance company decided to finally come in and defend the association once the owner had to actually file a lawsuit. So, the bottom line is there are a lot of things that should be covered. What is actually going to be covered, that you're going to want to run by your broker for the most part. But there are a bunch of different policies. I've also heard of legal insurance or litigation insurance that's been coming up lately, which is basically, I had never heard of it until about a week or two ago. And apparently it is essentially a policy that covers the cost of litigation that isn't covered by your other policies. So in other words, you're still only paying your deductible, even though you're not being paid or you're not being covered for purposes of any damages or anything like that. But at least you're not paying a law firm like ours out of pocket to pay the defense of that lawsuit. What you're paying is your deductible, which may be $2,500 to $25,000 to $75,000, depending on your policy. But you're only paying that out of pocket instead of the entire amount of attorney's fees and costs incurred. So that's a new one for me. I just had never heard about it until about 2 weeks ago. But apparently it's becoming more prevalent, partially because so many insurance companies were severely benefited by the legislation that came out a year or two ago that basically made it so that insurance companies can pretty much do what they want. So that this is a new cottage industry of insurance coverage that's come about partially as a result of that.
Riley in Orlando, can my association really evict me for unpaid assessments?
Yeah, that's the short answer. Yes. If you don't pay your assessments, the association has a statutory right. I don't care if it's a condo, HOA, or co-op. The association has a statutory right to eventually record a claim of lien against your property and foreclose that lien, meaning there is an actual auction, a sale of your property. The reason for this is that the declaration was recorded before your deed. So it actually supersedes even homestead rights in your property. And what that means is that, the association needs this money to perform services like collecting trash and things like that the association pays for, even if it's just insuring the common elements and there are no amenities or services whatsoever. It's still money that's needed to protect you from people that might sue the association for failing to do what it needs to do. So rather than make everyone responsible for those expenses, the assessments, which are basically the budget divided by the number of units for the most part, you may have it a little bit different in your community, but the assessments are intended to serve the necessary operating and maintenance expenses of the association. When people don't pay that, everyone else needs to foot the bill for it. So rather than, just leave everyone out in the cold and the people that at Steve, as we discussed earlier, already can't afford to live in your community unless the fixed income that they're on is actually going to cover everything, rather than have them pay more and end up being foreclosed because you didn't pay your assessments. The legislature and most declarations will allow the association to remove you from the property and have someone who hopefully will pay put in there.
Jack in Pine Hills wants to know, he said, I bought into a community and now I'm being told there are restrictions that I don't like. How was I supposed to know? What can I do?
You were supposed to look in the county public records before you purchased your property and see if there were any restrictions covering it. That's usually going to be showing up in your title search that the title agent did before closing. I fully acknowledge that most people don't think to do something like that or to even ask for a copy of the potential closing file from their broker, their realtor, whoever they're using. But the bottom line is anything that's in the county public records, everyone is considered to know about. So if you're not doing that county public records search before you buy your property to see if this property is subject to a condo, an HOA, a co-op, whatever type of community it may be, sorry, but that's it's literally buyer beware is the way that Florida works in this aspect. And you had knowledge of it, whether you actually knew or that knowledge was just constructive is the legal term. What do you do now? You can sell or you can comply with the regulations, or frankly, some people just ignore it and hope that the association doesn't care. If I'm working with an association and they don't care, I won't be working with them very long because they're putting themselves in a position where they're not going to be able to enforce things going forward. So all of the communities I think that our firm as a whole works with are at least being given guidance that you need to enforce all of those restrictions. And if you don't want to enforce them, you get rid of them and amend them out. But for someone who bought in not knowing that there was an HOA, they needed to, comply with the rules, regulations, declaration and covenants, etc. Sorry, but if you don't like it, you can sell just like you were able to buy. I hate to be blunt on that one, but that's really the only option.
Yes. We've really actually come to the end of the show.
Okay.
Give everybody your phone number and your website.
Sure. And Steve, thank you so much as usual for having me on. These things fly by every time, man. The number is 954-928-0680. Our website is kbrlegal.com. You want to email me, just put AS at before that, kbrlegal.com. Steve, thanks again. And thanks, as always, to everyone listening, watching, etc. We appreciate it.
Next time you're on, it's going to be board certified attorney Alan Swartzy.
Yes, sir.
Great. Congratulations, bro. You deserve it.
Thank you. Appreciate that.
And we'll be back again with you next week with more Ask the Experts. Everybody have a wonderful weekend. We'll see you soon.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.